This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. I'm Catherine Eaton, a collaborative family law attorney and a member of the Florida Academy of Collaborative Professionals. Today's guest is Rebecca Fischer, and she is the president-elect for the FACP. And so today she is going to speak. We're going to talk about cases with special needs and special needs children and how the collaborative process can address those needs. So thank you for being here today. And would you start off by just giving a little bit of background as to not only being the president-elect, but just your profession and what you do?
Sure. Thank you, Catherine. I appreciate you having me here. I have been practicing 41 years. The last 30 of those years have been in probate, estate planning, guardianship, and of course, family. I became entrenched in the world of special needs families about 20 years ago when my youngest child was diagnosed on the autism spectrum. And when the diagnosis was reported to me, I happened to be in my car, and in those we didn't have cell phones that had all the apps on it that allowed us to look up the words that we were being told. And I remember trying to memorize the kind of language that was being given to me to describe my son, and rushing home to look those words up, because I didn't understand what they were talking about. I mean, a word as basic as perseveration or any number of other kinds of words that are used to describe a child on the spectrum. So you immediately become immersed in something that's very, very overwhelming, and it becomes overwhelming for the entire family. And there are mixed reports on the statistics of the divorce rate in families with special needs children. Perhaps I'm a little biased and think that it's on the higher side rather than the same 50-50 statistic that we have in the general population, because I see so much of it, and I'm aware of the amount of stress it's put on families, not only the parents, but the siblings. And when it gets to the point that the family is buried in medical expenses and therapies, and at one time, a lot of this was not covered by insurance, and it's not covered to the degree that it should be. Providing a child with special needs, just with the therapies alone in the early years, can run as much as $60,000 a year. That doesn't include, if you're sending them to a special needs program, what the costs are of that special needs program. Back in the day when my son was in school, it was about $25,000 a year for the private school he was in. So it can wipe a family out. So when you then put them in a divorce setting where they're already worrying about where they're each going to live, where the neurotypical children are going, what their timeshare is going to look like, what the support is going to look like, and then you throw into the mix a child who needs more than your standard child support, most likely can't live within the framework of a 50-50 timeshare. It makes it very, very difficult, both for the courts and for the families and inexperienced lawyers in dealing with these kinds of issues, to work their way through the process. So as time went by, I came to the realization that families with special needs needed to be in the collaborative process. In the collaborative process, we can work through the kinds of issues I just talked about and accommodate the needs of that family and help them create a framework for timeshare that accommodates the needs of the neurodiverse child and doesn't necessarily impact the neurotypical children when you have the timeshare schedule. Are we frozen or?
You just froze, but your voice isn't. So there, and you're back.
Um, so what I do as well as having resources to help a team bring in a child specialist or the sort of adjunct or ancillary professionals that we need to work on these kinds of issues. And certainly the financial neutral needs to know how to work on these kinds of issues because there's most likely going to be a deviation from child support guidelines. The neutral facilitator is going to need to understand how to do the timeshare, which more likely than not is not going to be 50-50 for the neurodiverse child. You then have to look at issues like, is child support going to have to go beyond age 18 or high school graduation? More likely than not, it will. And this was actually how I ended up coming to the realization that these cases don't belong in court because I had built into my marital settlement agreement that child support would continue through age 21 because we did not know at the time whether he would go to college or go to vocational school or go to anything past high school. He ended up getting accepted early decision to a university. His dad filed a motion the very next day saying his son was no longer on the autism spectrum as evidenced by his early admission to university. There's no such thing as going off the spectrum once you're on the spectrum, but the judge didn't know that. And in a 10-minute hearing without any evidence of what my son's situation was, ruled in his father's favor and terminated my child support. So that, you can't have something like that happen. It just throws the whole family into a frazzle because I wasn't expecting that to happen. I now had a child going off to college with no ability to get additional assistance to help pay for the therapy and tutoring that he was going to need. So if you're in the collaborative process and you can really lock it in and get buy-in from both parents that this is in the best interest of their child, and in fact, they're going to do this, or if there's a chance that one of the parents may do what my former husband did, and that was to try and get out of it later, although I think judges are a little bit better educated today than they were back then. But you can put language in there that if there's going to be a modification sought on that specific provision, that you can't do it without reports from therapists and specially trained psychologists in the area of autism or whatever area of special needs you may have to consider. There are other considerations like, is the child going to need a guardian? Is it going to be what's called a guardian advocate? The guardian advocate statute has 7 specific diagnoses, with autism being one of them. Down syndrome happens to be one of them, that allows for a guardian advocate to be appointed without putting the child through incapacity proceeding. My experience with the general magistrate, and one of them actually spoke before our pod meetings for the Collaborative Family Law Institute to talk about the importance of working all this out while we're at the collaborative process table. Because if you don't, you go back and you attempt to do it later. And if the parent who's paying child support thinks you're only doing it because you want to prolong child support, there's going to be a battle. And it's a family battle that's being now taken into the guardianship court. And the guardianship general magistrates and judges really don't want to hear this kind of a fight going on because they're focused on the best interests of the individual who's being considered the ward. And these parents are only concerned about money, or one of them is, and not what's in the best interests of the child. So that kind of issue can get resolved at the collaborative process table. There are considerations that need to be discussed, like whether or not this is a child that's going to need a supplemental needs trust. And if so, meaning they're going to need government benefits, and so neither parent is going to leave their estate outright to the child, but rather into the supplemental needs trust. Are we going to agree that we're going to create it now and both fund it? And once he turns or she turns 18, child support will now go into the supplemental needs trust, because if it doesn't, you could impact their government benefits. So that's a consideration. There is something called an ABLE account. It's the Achieving a Better Life Experience Act. You can fund 18,000 a year into that account, and whatever's in that account will also not disqualify a child from getting government benefits if they're unemployable once they graduate from high school. So the parents can talk about who's going to fund into the ABLE account and who's going to administer the ABLE account. So there's a lot of issues that parents, or excuse me, attorneys that don't have experience in this area are simply not going to know to address. So I have a number of attorneys that know I do this kind of work that will call me and say, I have a client like this, can we hire you just to consult on these kinds of issues? And I've created an outline for the attorneys that really just get what the problems are, but don't have the language. So I just simply give them the language to make sure it's put into the parenting plan or the marital settlement agreement.
Thank you for sharing it. It's so important. I'll share that before I started practicing as an attorney, I was a corporate director at Easter Seals in West Palm Beach. So at that time, it was the only daycare for special needs children, and whatever therapies that they needed, speech or whatever it was, that the therapists were there. So the parents, one, would have a break, and two, they could go to work and know that they wouldn't be running around to this therapy appointment or that therapy appointment. They knew that their preschool age child was getting therapies and was surrounded by professionals who could help them that day. So, and then when I first started doing collaborative, one of my, first cases was special needs. So those issues that you just described are so important, and the court just isn't the appropriate place to lay them all out and have it decided. You just need the judge at the end to stamp it and say, so glad you reached an agreement. Yes, this parenting plan looks great. There's things in here that I don't understand, but I know that you professionals address them all. And so the collaborative process works so well for these families in this situation. And it's great to know that you have that experience and that concentration and have that checklist, because that's so important, that the parents don't even, you are then teaching the parents that don't even know these certain things, especially if they're young, they're just starting out. So it depends at what stage the child is.
Well,
so
and they're so overwhelmed. I open by saying just getting the diagnosis and hearing some of the language for the first time that comes with the diagnosis is overwhelming in and of itself. But you almost don't get out of that treading underwater feeling for a very long time, because every time you think you've overcome one hurdle, you're faced with a new one based on the growth of your own child and based on the milestones that they're hitting in their own lives. The reason I differentiate with autism, because I know that at least under the guardian advocate, and cerebral palsy happens to be one of the other 7 diagnoses, is because when there's a physical disability that you can see, parents are less likely to be in denial that the disability exists. When you're dealing with autism, unless it's a very low functioning child, and even in those situations, I've seen one parent just walk away still in denial that that's who their child is. you are dealing with a higher functioning child, and because the spectrum today is so wide in who goes within that diagnosis, it's so easy for parents to say, no, that's not my kid. No, my kid doesn't really need those therapies. You're just exaggerating this because you want more money out of me. So it takes a lot of work sometimes just to get the parents on the same page for what the child actually needs. Parents don't necessarily agree on discipline for the child, because one of the parents who finds that by placate, and this is true even in neurotypical kids, the parent who placates a child feels like that's the easier route to take, and so just pretty much gives in to anything that that child wants and becomes the good parent and the one that the child wants to be with. When you're dealing with an autistic child, the number of meltdowns, at least in my personal experience, that come with raising an autistic child is 200-fold more than what you deal with in raising a neurotypical child, because they'll melt down over anything in any place. Going to Publix was a nightmare. And it would simply be the lights and the smells in Publix. And I didn't understand that originally, but as I came to learn more, I realized taking him to Publix was not a good idea. And it wasn't just the outing, it was all the environmental stuff that was coming at him. So that's where I see the biggest arguments, because parents are, they can deny it easier and slough it off to behavioral issues, or just simply deny that it exists because they don't want their child to be that way.
Talk to me a little bit about when you're in the collaborative process, some of the professionals that you may bring into the team, because if you have the attorneys and they're knowledgeable about it and you're trying to get the parents on the same page. So what are some of the options for a collaborative team to explore in gathering the data information that the parents need in order to make decisions on what their parenting plan is going to look like?
I've presented on this topic quite a few times with the team, with the neutral financial and neutral facilitator, a child specialist. So if I get a case like that and another attorney, I will try to put that team together, because I know we all understand exactly what's involved. If not, if I have an attorney that, no matter how many times I try to explain what I said to you earlier, just can't be bothered to understand it. They're more focused on just getting through sort of the standardized textbook divorce, if you will, even in the collaborative process. I will try and bring in, there's one woman by the name of Tabitha Mizrahi, who is the associate head at my son's special needs school. She's an expert in knowing who else needs to be brought to the table, whether her skill set is the right skill set to be at the table. She knows how to identify what kinds of therapies the child needs, the kinds of issues that I'm talking about. She's very capable of advocating for those issues. Obviously, if I'm asking for them, I think it sits better coming from the expert in special education than me, saying this has, we really need to get this in here. So I think having somebody like Tabitha advocating on behalf of the child and what's in the best interest of the child is very, very important in these processes.
And then somebody like that, is that what you consider a child specialist? Just describe more what a child specialist is. And it sounds like there can be a child specialist in a lot of different areas and categories, but just would you please explain more what a child specialist does?
So
and
Florida has not adopted the child specialist model. There are some of us that have used them. I'm in a case right now that has gone on for quite some time. But there are 4 children who are impacted by a substance abuse parent. And we felt we needed a child specialist just to deal with the trauma the kids were going through. So that's one case where we would use a child specialist. In the kind of case that we're talking about with special needs, I think you really need a child specialist who knows more than any of us sitting at the table about what that child's life looks like, both today and in the future. Certainly through the end of high school, maybe not necessarily what the challenges are going to be like in college, although college is still a big consideration. Because if you want your child to succeed and they're capable of going to college, you have to consider what it's going to look like when they get there. What kind of supportive environment do they need to be in? But I think you need an expert or a child specialist sitting at the table helping decipher what those needs potentially could be. There's a lot that's unknown when you're dealing with a child on the spectrum because there's a lot of growth that could happen. I'm going to use the word awakening, which may not, be a clinical term, but there's a lot of awakening that could happen, through the high school years. I mean, my son, I think, was in 5th grade when I was told he was capable of going to college. I think some parents maybe found out a little bit later, but I got divorced when he was in 2nd grade. We had no idea. If we'd had a child specialist there, I think that my settlement agreement would have looked very different because we just didn't know. We didn't know what to expect or what to even write.
That makes sense. So going forward, and it seems like there's a big difference when you have children. You made the point, like when you got divorced and your son was in 2nd grade, and then finding out, oh, he in 5th grade, there's this option that, or a track that he may be going to college. So can you talk a little bit about when you don't know when your child's so young versus when your child's older, but still that you just don't know? I guess the question is like, because you don't know when you're married, you don't know when you're divorced, the child changes and there's an awakening, and it's something that's in constant change. So how do you have a parenting plan that's in black and white? Talk about some of the options, because you just don't know. You don't know what the future holds. You don't know what the child is capable of or what the child wants and gravitates towards. So can you talk about a parenting plan, and how do you write one that is flexible and open to all the unknowns?
Now here's the difference between the way it was done sort of back in the day, 2007, when mine was mediated, and the way we can have the opportunity to do it today. In 2007, I knew nothing about collaborative, even though it was around. We mediated our agreement. We never litigated. All the litigation came after the settlement. And so it was a rather simple statement that just said, we do not know if he's able to go to college, but in that vein, child support will continue until age 21. And that was intended to say that it would continue if he didn't go to college, because I would need the support to take care of him at home. Or if he did go to college, he was going to need tutors and guidance professionals and support. So, because for kids that are on the spectrum that go away to college, the academics are one component of it, and they can usually handle the academic component, maybe with some tutoring. It's the social piece that is incredibly difficult for them. What I didn't know in 2007 was that I really didn't have buy-in from his father. So again, when he got an early decision to American University, his dad's first reaction was, oh, wow, he's not on the spectrum anymore. Let me file a motion to terminate the child support without any consideration of what it would take for him to succeed in college. And to me, that was the key. What did we need to do to make sure he was successful? And the judge simply didn't understand it. I mean, there's no way you can make a decision in a 10-minute hearing that a child's no longer on the spectrum. It's just not plausible. And frankly, an outcome like that is impossible. They weren't going to find anybody to testify that way. When I walked out of court that day, all that was going through my head was, if we had been in the collaborative process, if we had had some expertise at the table to say to both of us, so that it was truly a meeting of the minds and a decision that we both understood was important for our child. This is what his future may or may not look like. Here's what you need to do to prepare for either eventuality, which we can do in the collaborative process. You don't get to do that in court. You can do it at the kitchen table, but you may not have the skills to know what you don't know. And that's huge. You don't know what you don't know, which is why I advocate for having a child specialist in the process who does know what you don't know. I always wonder if I might have had a different outcome if we'd gone through the collaborative process and not sat in a room with my former husband having no attorney, me having an attorney who kind of got it to the extent that we got it at all in 2007, and a mediator who just didn't know and really didn't care.
So if somebody is going through a divorce, starting the divorce process, they've heard the podcast, they're interested in using the collaborative method versus the litigation method, they have a child with special needs, what's the next step in finding an attorney or starting the collaborative process? What's your advice to that person who's listening to this podcast and says, aha, me too? So where do they go for help?
Well, I don't know if the podcast is the place to say, please feel free to call me. But certainly feel free to call me, whether it's to ask me to consult on a case because you have an attorney, and we can decide whether it's a full-on participation in the case, or I simply provide you with the check sheet and talk to your attorney once to say this is what needs to go into the parenting plan and this is what needs to go into the marital settlement. But I have to caution people that when that's my role, the attorney who's not experienced in that area typically gives all that up in the settlement negotiations because they don't always grasp the importance of it. And so when they think about what they can negotiate away, it's all those provisions I went over with you at the beginning. 100% of the time they've been negotiated away by the unexperienced attorneys. So you can go to the website of FACP. You can go to the website of the collaborative practice group that's in your county or this, the contiguous counties to you, and look for the attorney that resonates with you. But ask questions about them. What do they know about a child with cerebral palsy? What do they know about working with the needs of a child with Down syndrome or autism spectrum disorder? You want to make sure that you're working with an attorney who understands what the needs of your family are, and not just the needs of your special needs child, but the needs of the siblings, because the siblings are in it too. And they have their own mishigas, as we say, going on in the family dynamic because they're suffering. They're not getting the hands-on attention because the special needs child is taking more attention than there's time for all, if there's 2 or 3 kids. So you want somebody that understands that and that will put a team together, a financial neutral, neutral facilitator who can work understanding what the needs of the family are.
Thank you for that. And thank you for sharing your knowledge, your experience today.
Thank you for having me. It was a pleasure.